Good morning, everyone, and thank you for joining us. I'm Jane McMonagle. I'm a partner and head of the transactional construction team here at Brodie's, and our team deal with advising clients at the front end of a very wide variety of projects. Our 40-strong team of construction lawyers work across the whole of the UK, and many of our lawyers are dual Scots and English law qualified. Our team is both Tier 1 and Band 1 ranked in the legal directories chambers and Legal 500, which we're very proud of. And today we will firstly outline at a very high level some current trends that we're observing in construction contracts. We will then look at the interaction between process plant and civils contracts for clients operating within industrial sectors such as the drinks industry. We've spoken before about contractual provisions around sustainability, which is a focus for so many of us at the moment. So we'll provide an update on what we're seeing in construction contracts on that front. And lastly, Claire Rice from our contentious construction team will provide an update on some important new case decisions. So some important news to start with as a heads up. Last week, the JCT published the first of its new edition of standard contracts, the JCT 2024, starting with the design and build contract. And the anticipated new contracts bring in a number of changes, including notices by email, gender neutral language, clauses in relation to collaborative working, sustainable development and environmental considerations now becoming standard, amendments to extension of time provisions, together with more other minor amendments. Notably, the D&B 2024 does not contain an overall cap on the contractor's liability, but the guidance notes do recognise that the parties may wish to consider this and provide some guidance on the topic, which is a real first for JCT. Our construction team will be publishing content on these new forms in more detail over the coming weeks, so watch this space for the updates. So we thought it helpful to provide some observations on patterns in the industry which we're identifying at the moment. And the first one of these is less tendered projects and more negotiated contracts. So there appear to be less top tier contractors having a real appetite for certain types of projects, such as PBSA, which is student resi, or BTR, build to rent. And to secure a reliable contractor with a solid covenant, rather than going out to competitive tender, many developers are engaging with a contractor very early on, getting them on board to work through the various design stages to finalise and negotiate a contract. Now, tendering costs are significant for contractors who are preferring early onboarding and engagement in the current market. Some clients are also being more adventurous with the choice of contract forms. So JCT is still the preferred form we are seeing for straightforward new build commercial development, but we are seeing more use of NEC, IChemE and FIDIC forms, in particular with clients in industrial sectors. And I'll come on to look at some of these in the next section. Projects are generally taking longer to get off the ground, and whether this be down to a delay in planning or feasibility studies and appraisals just not quite stacking up, or trying to value engineer, meanwhile construction costs are rising. So we are seeing many projects come out of the ground, but there is no doubt that there are challenges to be overcome at inception stages. Well known, but we have a tricky insurance market at the moment. PI in particular is getting difficult to obtain and to maintain. Insurers are imposing a lot of conditions and inputting into contract terms. And we're also seeing more discussion generally around works insurances and what is appropriate given the nature of different works. As you will all know as well, the cost of construction is very high. It is continuing to rise, and the cost of money itself and availability of finance is still impacting projects. Funders are being quite selective, but we are seeing a lot more alternative lenders becoming involved in development finance now. But notwithstanding all of that, there are positive signs, and we are definitely seeing more activity this 6 months than the previous 6 months. Developers are becoming more active, they're navigating these tricky issues, and some funding is being unlocked. So there are a lot of rays of light and a real momentum to push ahead. So on to the next slide, please. We regularly assist clients operating in industrial sectors on projects that include both process plant works and civils construction works. And civils construction works which are being carried out by separate contractors. for example in distilleries. When a process plant is being designed, installed and commissioned, it will often be housed in a new or a refurbished building, and typically different contractors will be responsible for the civils, building works and the process plant, but will often be required to work together on the same site at the same time, so a neat interface and integration is really required. On to the next slide, please. There are various contractual structures available for these projects. On this slide, we have outlined what we see as the most commonly adopted structure. So here, the design and construction roles are carried out by different parties. The employer appoints a construction civils contractor, typically under a JCT, a process plant contractor under an EPC, which means engineer, procure and construct, and a team of professional design consultants, sometimes under a multidiscipline consultant. So there are essentially 3 points of design responsibility in this model. The process plant contractor is only responsible for the design that it prepares, typically all design of the process plant. The construction civils contractor is only responsible for the design that it prepares. There's usually a traditional JCT contract used where there is a contractor's design portion, and that's where specific areas of design responsibility are taken on by the construction contractor. The balance of the design responsibility lies with the design team, and typically it is the designers who take responsibility for design interface risk between the process plant works and the civils works. So importantly, using this method, no one party wraps all of the risk is very much spread. On to the next slide, please. With this next option, there are only 2 points of design responsibility rather than 3. So as per option 1, the process plant contractor will take full design risk over the design of the process plant, but the construction contractor will take full design responsibility for the civils construction work under a design and build contract. So there would also be an expectation that the construction contractor takes the design interface risk as between the design of the construction works and the design of the process plant works. Your design team would fall under the civils construction contractor. And from a legal risk management perspective, this route is preferable to option 1. However, in the current market, it's not something that we're often seeing used, I think really due to a pushback from the civils contractor and the design consultants. Moving on to the next slide, please. Option 3. So with this option, there is only 1 point of design responsibility. So one contractor, typically the civils construction contractor, wraps all of the design and construction risk, including the risk of the process plant contractor and the design team. So the process plant contractor would be engaged as a subcontractor. The design team would be novated over to the civils construction contractor from the employer. And from a legal risk management perspective, this is definitely the best option. But what we would say is it is not the approach that we have seen taken on the most recent distilleries that we've been involved in. It could be quite difficult, I think, to achieve in the current market. Even if it is achievable, it would likely carry a large risk premium. So in summary, option 1 on the first slide is most frequently used, very occasionally option 2. On to the next slide, please. And one of the recurring themes that we observe in projects of this nature is that there is a perceived limited pool of contractors or consultants with the relevant expertise to do this work. Those parties, therefore, generally have greater bargaining power than we would see in other types of projects. Clients are often being led by those contractors without as much control as would be preferred or as would be expected. Yeah, great. Sorry about this, folks. The joys of live recording. One of the ways to mitigate this is really to consider how a project is procured. In an ideal world, when procuring a project, first of all, your client will identify the requirement and the project delivery method. The client will assemble the core internal project team and allocate roles accordingly. So that will include technical, financial, insurance and legal, all within the organisation. The client team then reaches out and does some soft market testing, and all external advisors are assembled, including technical, which will be project manager, quantity surveyor services, and any design consultants. Insurance and legal, I know I will say this, of course, but the earlier the legal team get involved in the process, the better, and the same goes for insurance advisors. The team should decide on the contract form and procurement strategy and consider tendering options. The project then goes out to tender. And very importantly, the contract conditions should be drafted to table with any tendering contractors pre-appointment, and any comments should be requested by tender return to properly assess the bid. The contractor will then be appointed following negotiation of the contract. On to the next slide, please. And we've got some pictures here. So the JCT contracts are usually your go-to contracts for carrying out core construction works. And the suite includes different forms of contract intended for use on projects of varying scales, values and complexity. And as mentioned, we're most commonly seeing traditional JCT contracts used in this space rather than design and build. Broadly speaking, the JCT contracts are balanced forms of contract. They share risks between employer and contractor, but they are usually amended to adjust the risk profile so it's generally more favourable to the employer. Amendments can also be made to address interface and coordination provisions with the chosen process plant contractor. On to the next slide, please. Process plant contracts are performance-based. So in a distillery context, for example, what is important is that the client can produce high-quality spirit to their required specification and output and to the volume and the timescales required. And as such, EPC contracts are the most appropriate type of contract. And there are various standard form contracts which can be used, such as IChemE, MF1 and FIDIC forms, and their colourful forms are all on this slide. Which form of contract is most appropriate will really depend on a variety of factors, such as familiarity with a particular standard form, importance of control, delivery time and cost, or particular performance specification and testing requirements. And in terms of industry patterns, no clear form is best and all can be amended to suit. Interface provisions will always be a consideration to be addressed. And on to the next slide, please, looking at the main differences between construction and process plant contracts. So generally, process plant contracts are performance-based, as I said, rather than traditional construction contracts being work-based. And some of the key differences between these types of contracts are, firstly, design and fitness for purpose. So a process plant contract will typically expressly include a contractor's fitness for purpose obligation, but a pure construction contract such as JCT will not. So for example, a FIDIC and IChemE will expressly require the plant or works to be fit for purpose. A process contractor is also typically expected to take on full design responsibility. Next one up is testing and commissioning. So a process plant contract will contain a very detailed, usually, testing and commissioning process to ensure that the completed plant will operate to the performance standards required. There are often various stages of testing, including pre and post takeover. On performance specification, a process plant contract will often contain minimum performance parameters for the plant. So that could be around the quantity or quality of the product to be manufactured. And there may also be performance guarantees required with performance damages applying. Exclusions of liability and caps on liability. So a plant contract will typically contain more exclusions and caps on liability in favour of the contractor than you would typically find in a core construction contract like a JCT. That would include a total financial cap on the contractor's liability. Consequential loss is very often excluded in process contracts, and that's really because the potential losses incurred by the employer would be so disproportionate to the value of works performed that they shouldn't be budgeted for by the contractor, and it perhaps wouldn't be reasonable to expect the contractor to take them on. Insurance arrangements. Each standard form has its own insurance requirements. Some allow the parties to decide who takes out the all risks insurance, some will specify who it should be. And given it's likely there'll be at least 2 contracts in place for works on site at the same time, the insurance requirements should be considered holistically to ensure that each part of the works is appropriately insured and that there are no gaps or double insurance concerns. Early notification and engagement with insurers is advised. final certificate and cut off on liability. So one last point to finish on here. And unlike a typical civils contract where the contractor will be on the hook for breaches of contract for the full duration of the contract, so typically 12 years in England, sometimes potentially up to 20 years in Scotland, subject to law of prescription. Under many forms of process plant contract, such as IChemE and MF1, the contractor's liability ceases much earlier, for example, an issue of the final certificate or on expiry of a 3-year latent defect period per MF1. On to the next slide, please. So looking at the interface between construction and plant contracts, looking at the practical interface, sometimes the sheer physical size of process plants, so for example, pot stills for whisky making, can only be housed in the building if they're brought to the site and installed before an element of the core construction works are completed, so roof or glazing facade, for example. But the process plant can't be installed until elements of the new building are complete, such as foundations and groundworks. Construction and plant contracts don't expressly speak to each other as such, so the employer could be stuck in the middle, carrying all the risk in terms of interface between two contractors. It's all well and good having two great designs, but if they don't integrate properly, it could result in a building or plant that doesn't quite meet the employer's requirements. And this is where bespoke drafting and complementary interface provisions can provide the employer with some protection to mitigate its exposure to risk. On to the next slide, please. Thanks. Key interfaces and timings between the core construction work and the process plant installation will need to be developed, of course, at a technical level first. So that could include exchange of design information, timing for elements of the works that are a precondition to the process plant being installed, or testing and commissioning required before any element of the process plant can be covered up, for example. So interface requirements should be factored into programme and pricing at tender stage, enabling the employer really to manage its own budget and its appetite for risk on the project. So we've set out there generally the interface issues that will need to be dealt with, and they include commencement and completion dates. So once on site, both contractors' activities need to be coordinated so that they don't hinder each other. A master programme that accounts for all activities is really imperative and exceptionally helpful to have. Entitlements to extensions of time. So if one contractor delays the other, what are the consequences? What relief will you grant the delayed party? Again, all of that should be documented. Liquidated damages and trigger points. If a contractor doesn't meet a milestone and that results in another contractor being delayed, is there a need to reimburse the delayed contractor for delay costs? Knock-on liability, the potential damage, loss and liabilities that could be incurred by the employer under one contract through the acts of the other should be considered. And insurance, so as I've previously touched upon, is a project policy perhaps or an owner-controlled insurance policy more appropriate? Are risks the employer is retaining sufficiently insured? On to the next slide, please. How to deal with interface issues. So there are principally two contractual ways of dealing with interface issues. Firstly, an interface agreement, so that the employer is off risk and the contractors deal with liabilities between themselves. Now, we would observe that this approach of using an interface agreement hasn't been one that we've seen taken on a recent distillery projects. And it could arguably be overkill perhaps or unacceptable in the current market, but it is a contractual way of providing for the interface. The common compromise really is to include interface provisions in all package contracts for the project. So we've been involved in a number of distillery projects in particular that have successfully adopted this approach. One way to document interface provisions is to schedule out a regime of key milestones and corresponding dates or time periods to complete various tasks, reflecting the agreed programme to allow each contractor unhindered or dominant access to parts of the site. Where one contractor is in culpable delay, the prolongation costs of the other contractor could then be recovered at a liquidated or pre-agreed rate. Other typical interface provisions we've seen are provisions requiring each contractor to review and comment on any documents submitted by the other, which will deal with interface issues. General obligations on contractors to coordinate and responsibility for design. So that's a very high level run through our approach to interface between core construction contracts and process plant projects in the industrial sector. I will now pass over to Kirstine, who is going to consider sustainability and contractual approaches to such.
Thanks, Jane. Good morning, everyone. As sustainability and the drive to net zero are still matters that are high on people's agenda, I was asked to speak about the relationship with construction contracts and projects. I am, however, conscious that in our last webinar, I also spoke about sustainability, focusing on contractual mechanisms we were seeing. So today I'm going to give a brief recap of these, as well as looking at some practical measures. So by way of a reminder, net zero is essentially the state of no longer adding to the total amount of greenhouse gases in the atmosphere. And the UK's Climate Change Act of 2008 sets an emissions reduction target of 100% by 2050, and Scotland aims to hit net zero by 2045. It's widely acknowledged that the built environment is a significant contributor to greenhouse gas emissions. Whilst figures differ between studies, it does seem to be around the 40% mark. Therefore, construction works need to be done more sustainably, using materials and plant that allow buildings to be operated differently if we're going to achieve net zero. Increasing sustainability requirements in construction contracts might be one way of achieving that. So as a recap on emerging sustainability provisions, industry bodies such as JCT, IChemE, FIDIC, Logic and NEC have already published provisions, albeit fairly basic, and those have been drafted to specifically address climate change concerns. The provisions demonstrate that the industry is seeking to focus parties on environmental issues, but have very much left it to the parties to decide how much consideration is given and how they are monitored. NEC's X29 is probably the most substantive and publicised standard form provision relating to sustainability. In brief, X29 obliges the contractor to comply with climate change requirements that are set out by the client in the scope documents, and that operates in tandem with a climate change plan that's created by the contractor and sets out its strategy for meeting the client's climate change requirements. The not-for-profit Chancery Lane project has also developed a series of bespoke clauses that are available for use by the public to incentivise climate-positive behaviours across a range of sectors, including the built environment. I'll come back to some of the Chancery Lane project clauses when I look at different ways of thinking about how to build sustainability requirements into the construction process. So generally speaking, in a construction contract, there are legal terms and conditions at the front, and the technical documentation is attached that sets out the detailed requirements as to how the works will be carried out and what end result is required. With that in mind, it is still quite rare to see specific obligations relating to sustainability sitting within the terms and conditions of a contract, although I do think it's becoming more prevalent. The current practice, probably in most instances, is for climate change considerations to appear in a construction contract's technical documents. And that's because they typically relate to outcomes achieved through design and improved methodology. So for example, offsetting and/or minimising carbon emissions throughout the construction phase, the specific use of materials that minimise the carbon footprint of developments, and the ultimate performance and energy efficiency of a completed development. Now, it could be argued that additional legal contractual clauses aren't required if requirements are clearly set out in the technical documents and there's a clear contractual requirement to comply with these documents. It has been recognised by the construction playbook that modular or off-site construction has noticeable benefits, regardless of whether all or some of a development is being built off-site. Less waste is typically generated when compared to traditional construction methods, and due to the controlled factory environments in which modules are fabricated, materials can be optimised, reused and recycled quite efficiently. The Building Research Establishment suggests that waste savings of up to 52% can be achieved using these types of construction when compared to traditional methods. I've spoken previously about the contractual challenges that modular construction brings, especially in private sector developments where there's development finance, and even more so if modules are being manufactured out with the UK. Framework agreements also have a few advantages. As they're usually in place for several years, they can be an opportunity for parties to enter into standardised long-term sustainability commitments that don't then require renegotiation between projects. They make it easier for clients to drive sustainability and have KPIs across multiple projects. Early contractor involvement is a flexible approach that's often raised by us as a way to better facilitate discussions and collaboration on sustainable development, design elements and materials. By allowing the discussions to happen at an early stage, then there's a greater opportunity to identify cost and other efficiency savings and discover and review lesser known sustainable material alternatives and plan sustainability into decision-making generally, especially if, for example, certain sustainable materials have longer lead-in times. Some of the Chancery Lane project provisions focus on sustainable construction practices throughout the construction phase. So I've mentioned a couple there. We've got Ashcan's clause, which requires a contractor to comply with a schedule of sustainable working practices that have been agreed by the parties, and Francis clause, which requires a contractor to recycle where possible and use its best endeavours to minimise waste and turn waste material into diverted waste. Using more sustainable materials has long been a focus of parties trying to make projects less damaging to the environment. And if we look at concrete and steel, it's reported that cement production is responsible for about 7% of the world's carbon emissions, and steelmaking accounts for between 7 and 9%, around half of which goes into construction. The biggest barrier to using more sustainable materials appears to be the additional cost of, for example, recycled steel, bamboo, and reclaimed wood, as well as perhaps more limited availability. But while sustainable and energy efficient materials may have higher upfront costs, they might prove to be economically viable over the life cycle of a building. And related to that also is the use of plant that's more energy efficient to generate heat and electricity, but we don't have time to consider that today. There's a couple of case studies that we're aware of that provide practical examples of the use of sustainable materials. So the Innovation Hub in Dundee was designed with a glulam and CLT structure instead of a conventional steel construction. And apparently the use of those two timbers saved an estimated 650 tonnes of carbon dioxide. Another study is the new operation and training headquarters in Inverness. And Recyclate concrete was used there to install an industrial floor slab. And that sustainable concrete embodies lower carbon compared to traditional cement, and it also upcycles waste from incineration, reducing materials going to landfill. Whilst there are a lot of different sustainability standards, and I've referenced quite a few on the slide there, I'm not going to go through all of those, you'll be glad to hear. I am going to mention briefly BREEAM, PAS 2080 and Passive House, as these appear to be the main standards that are gaining traction within the UK construction industry. So in relation to BREEAM, that's a standard that's been about for years. It's a family of assessment methodologies that aims to help construction professionals understand and reduce the environmental impacts of the developments they design and build. And using BREEAM, it's possible to measure the performance of a building over a wide range of environmental issues to produce a rating ranging from pass to outstanding. PAS 2080 is a globally applicable standard for managing carbon in buildings and infrastructure. It provides parties with a framework to identify and mitigate carbon emissions across the board through improved design, facilitating the adoption of innovation and more efficient construction and use. And it's a key reference document in the UK government's construction playbook, and therefore seems to be increasingly becoming the go-to specification for carbon management in the built environment. And then Passive House. So Passive House is a voluntary thermal comfort and energy standard, and it provides a set of tools and processes to design, build, commission and hand over a low energy building with high thermal comfort. We're seeing an increase in use and inclusion of specific provisions relating to building to Passive House standards. Many of the schools that are currently being built in Scotland are being built to a Passive House standard. Now, compliance with a standard or scheme is often a business decision based on cost, but whilst it may be more expensive to follow these standards or schemes initially, in many cases, they allow for completed developments that are more likely to generate a higher rent or higher capital valuation, cheaper to run in terms of energy costs, and are more easily capable of meeting current regulatory requirements or guidance on the environmental performance of buildings. And it has been suggested that green premiums will become more available for energy efficient buildings, whilst brown discounts or price trips will be expected for buildings that are less efficient or sustainable. And JLL's research on the issue has revealed that in London, an 11.6 premium is placed on rental units that are green certified. So that was a bit of a whistle-stop tour of some of the different things to think about relating to sustainability. And I'll now pass over to Claire for a bit of a change of topic.
So today I'm going to talk about two Scottish decisions, both issued by the Court of Session in February this year, which may impact on the ability to pursue or defend claims. First case I'm going to talk about is the Engine Yard Edinburgh Limited and Allen Build Limited against Bain Stevenson Associates. This is a major decision concerning collateral warranties and prescription, and Brodie's were instructed on behalf of the engineer in this case. So by way of background, the Engine Yard Edinburgh project was developed by Places for People Developments Limited. Places for People Developments appointed two of its subsidiaries in the project, Allen Build as design and build contractor and the Engine Yard, who owned the land, to manage the project for them. Allen Build appointed Bain Stevenson as structural engineer under an appointment letter dated May 2017. In what's fairly common wording, clause 6.1 of the engineer's appointment letter required the engineer to execute and deliver a collateral warranty in favour of the Engine Yard and any lessee, purchaser or funder within 7 days of a written request from Allen Build. Issues arose during the project, which Allen Build said resulted from BSA's performance. Allen Build made a written request to BSA for a collateral warranty in August 2022, some 4 years after the date of BSA's appointment. The Engine Yard raised court proceedings against BSA, seeking delivery of the collateral warranty and damages for the cost of remedial works which were carried out on the project. The Engine Yard had no direct contractual relationship with BSA, but they argued they had title to sue on the grounds that BSA's appointment with Allen Build had intended to confer benefits on the Engine Yard, such that third-party rights were created in its favour. Allen Build then later joined the court action and demanded that BSA deliver up a collateral warranty in favour of the Engine Yard. So it was common ground between the parties that the obligation to deliver a collateral warranty expired after 5 years. What was in dispute was when the 5-year period started to run. The 5-year time bar period comes from the Prescription and Limitations Scotland Act 1973, but the clock will be stopped if a court action is raised. So the engineer argued that the obligation to deliver a warranty ran from May 2017, the date of the appointment letter. As 5 years had passed since the date of the appointment without any court action having been raised, the obligation was extinguished and Allen Build no longer had any right to a collateral warranty. The pursuers argued that it was the written request for a collateral warranty which was the trigger, crystallising the obligation to deliver it, not the date of the appointment. So they said that the time bar clock ran from August 2022, when the written request for a collateral warranty was made by Allen Build. As the court action had been raised within 5 years of that request, they said that their right to require delivery of the warranty had not expired. So the court held that there was a presumption that the obligation to deliver a collateral warranty was enforceable immediately. There was nothing in the engineer's appointment to displace that presumption, and so the obligation existed from the date of execution of the appointment. The contractor could have enforced the engineer's obligation to execute and deliver a collateral warranty as soon as the appointment letter was entered into, but they chose not to do so. As more than 5 years had passed since the date of the appointment without court proceedings being raised, the contractor no longer had the right to require a collateral warranty from the engineer. The court also held that the contractual structure pointed away from an intention to create third-party rights in favour of the Engine Yard, although that was irrelevant in any event, as the Engine Yard's entitlement to a warranty would also have been time-barred. The action against the engineer was dismissed. So in terms of key messages from the case, there's a general presumption that if the right to call for delivery of a collateral warranty under Scots law is not exercised within 5 years of the date of the contract, the right will be lost. This decision will change the practice and timing of obtaining and delivering collateral warranties, and we anticipate it might lead to panicked demands for delivery of warranties. So parties should check their contracts and delivery timescales when warranties have not yet been called for or executed and delivered. The second case I'm going to look at is FES Limited against HFD Construction Group Limited, and Brodie's acted on behalf of FES in this case. Up until now, time limits under a JCT SBCC contract are directory rather than mandatory. So if you do not comply, you do not lose rights. You can contrast that with the NEC form of contract, where if you do not notify a compensation event within a prescribed period, there is no entitlement to time or money. In this case, the Court of Session considered whether notice was a condition precedent to claiming loss and expense. FES Limited and HFD Construction Group entered into a contract to carry out works at a property in Glasgow. The contract was based on the SBCC standard building contract with quantities, and it contained the following standard clauses 4.20 and 4.21, and the wording of the clauses is set out on the slide. Clause 4.20.1, the key parts of the clause are underlined. If in the execution of this contract, the contractor incurs or is likely to incur any direct loss and/or expense, he shall, subject to compliance with the provisions of clause 4.21, be entitled to reimbursement of that loss and/or expense. And then clause 421.1 goes on to say that the contractor shall notify the architect/contract administrator as soon as the likely effect of a relevant matter on regular progress or the likely nature and extent of any loss and/or expense arising from a deferment of possession becomes or should have become reasonably apparent to him. During the course of the works, FES encountered delays. A dispute arose between the parties as to FES's entitlement to an extension of time and associated loss and expense under the contract. The dispute was referred to adjudication, where the adjudicator found that FES was not entitled to reimbursement of loss and expense under clause 4.20 of the contract due to its failures to give the required notice under clause 4.21. FES took the matter to court, seeking declarator that the notice provisions in clause 4.21 were not conditions precedent to any entitlement to reimbursement for direct loss and expense in terms of clause 4.20 of the contract. FES also sought the consequential declarator that the adjudicator's decision on that issue was no longer binding on the parties. Just as an aside, a condition precedent is a clause in a contract that provides that certain obligations under that contract will only come into force if and when specified conditions are met. So the court found that the adjudicator was correct and that notice requirements under clauses 4.20 and 4.21 are a condition precedent to claiming loss and expense. The court stated that there was no dispute between the parties that the task which the court must undertake is to ascertain the intention of the parties. The parties' intention can most obviously be found by determining the objective meaning of the language which the parties have chosen to express their agreement. So applying that to clause 4.20(1), the court found that on its face, the language used in clause 4.20(1) is clear and straightforward. It indicates that the contractor's entitlement to reimbursement is subject to compliance with clause 4.21. It is difficult to construe this language other than that it creates a condition precedent. To construe this clause otherwise would involve having to delete or ignore this critical phrase. FES had argued that the clause did not spell out the consequences of non-compliance with the provisions of clause 4.21, and as such the parties could not have intended to create a condition precedent. However, the court was not persuaded by this and said that far from not spelling out the consequences of non-compliance, the wording of that clause makes it clear that without such compliance, the contractor is not entitled to reimbursement. FES made a number of arguments based on business common sense and disproportionality. However, the court found that it was unnecessary to consider those factors, saying that where, as I have found in the present case, the language the parties have used clearly discloses their intention, it is not for the court to second guess what it considers business common sense might otherwise have dictated. The judge concluded that the obligation to comply with Clause 421 was not an unduly onerous one. Benefits in the form of timely and well-administered contract administration can reasonably have been anticipated as accruing to both parties from that compliance. Difficulty for the pursuer is that on the basis upon which I am to proceed, those obligations were not complied with by it. As a result, if compliance is a condition precedent, the pursuer has lost its entitlement, and the court dismissed FIS's action. This is an important case because it firmly establishes that the notice provisions under clauses 420 and 421 of the SBCC contract are conditions precedent to a claim for loss and expense. Any party to an SBCC contract will need to strictly comply with the requirements of these clauses if claiming for reimbursement of loss and expense caused by delay. Notification of loss and expense will now be subject to much more scrutiny. As well as ensuring that notices are given in a timely fashion, those claiming loss and expense should take care to comply with any contractual requirements concerning the form and content of notices, including where and to whom they are to be given.
Thank you, Claire. Some very significant decisions there for the industry, we think. So we have time for a couple of questions. Kirsty, I think the first one is for you. That's around what type of sustainability provisions are we seeing most frequently in contracts at the moment?
Thanks, Jane. So I think probably what we're seeing the most in terms of front-end stuff is probably just quite simply a requirement to comply with a particular certification. So for the example that, the building, you will need to have a BREEAM Excellent rating when completed, or possibly relating to, the EPC rating. So maybe an A or a B if people are wanting to have energy efficiency buildings. And I would say that in my experience, that usually that's going to be end user led. So if it's a developer of an office building, then they might look to that because that's something that might be particularly desired by their tenants. The Brodie's office at Capital Square is probably a sort of a prime example of that. What I've not really probably seen today is, although I mentioned X29 being the sort of clause in the industry that people speak about quite a lot in relation to NEC. I've seen quite a bit of discussion about that being used, particularly on public sector projects, but probably haven't really seen it used, like to fruition throughout a project. So that's one, I suppose, from my perspective, that I'm quite keen to keep an eye on.
To see being used. Yeah. Thanks. And I'll take this question actually just before we finish up. And it's around the publication of the new JCT forms. Do we think it's likely that the 2024 forms will reduce the length of schedules of amendments that are prepared? I'd probably say, the changes I don't think are too material to the 2024 forms. I don't think that's necessarily going to have an impact on the size of schedules of amendments. I think the industry's changing, actually. I think we're changing on that. We are looking probably, even from developer, if we're acting developer side, to slightly reduce the length of schedule of amendments. There is a lot more negotiation in contracts now, and I think there are certain points that there are normal compromise positions being reached on, which we are trying to, in our own schedules of amendments, address and take a very commercial view on what is achievable in the current market. So it may be the case that JCT will have some impact on the length of schedule of amendments, but I think there will be a move to a bit of a reduction in some of the supplemented terms or additional terms anyway, just because, again, the way the market is moving. So I think that is us at time now. Thank you very much for joining us today. And also, if you have any questions at all on anything today that you would like to raise offline, then you know where we all are. Our contact details are there on screen. Be a pleasure to speak with you all. Anyway, thank you and enjoy the rest of your day.